Again, durable survives incapacity. There is also a kind of power of attorney that's called a springing power of attorney. It springs into effect upon incompetence. The problem there is to determine when you become incompetent. Generally, we put in a provision that says two physicians, one of whom is my primary care physician, must record an affidavit in the county records office that says I am incompetent. Again, the general or limited just defines what your attorney in fact or your agent can do with your power of attorney. A limited power of attorney may only allow that person to go in and sign a deed or to sign a mortgage. But generally, for a general durable power of attorney, you want broad flexibility. You want that agent to be able to do anything for you to give you the maximum benefit. Provisions that should be included in a general durable power of attorney, specifically the power to convey title to real estate if you want that, and specifically the ability to make gifts. That person that you have appointed, that agent, is a fiduciary, meaning that they have an obligation to act in your best interest and generally not to engage in self-dealing. Gifts become important in many situations, one of which is Medicaid that we're going to talk about just very briefly. And if you want that person to be able to make gifts to themselves or to others, you must specifically say so in that document. That's case law in South Carolina. It may differ from state to state as to whether gifts may be made using a general durable power of attorney, but in this state, it must say specifically. We generally include lots and lots of specific provisions because we've had companies, brokerage firms, banks tell us, it doesn't say you can do this, so we've included it. Make sure that there are specific security provisions in there so that your agent or your attorney in fact can act with regard to stocks and bonds and other securities. Provisions relating to safe deposit box in this state by statute must be included specifically. You want to address compensation. If you want them to be paid for their service, you should say so. If not, it's going to be up to a probate judge as to whether they're entitled to any compensation. They may take compensation and nobody may ever know about it, but they have to, your agent has to give you an accounting upon request. If you're incompetent, you can't request an accounting, then we're back to court and we're squabbling and having lots of legal fees spent to resolve these issues. And the manner in which you revoke it must be the same in which you made it. So if you made this power of attorney with 2 witnesses and a notary, you have to revoke it with 2 witnesses and a notary. If it's recorded in the county records office, you have to record the revocation there. Now, more tax planning, mechanisms for estates subject to estate taxation. We definitely want to use trust to maximize that credit, that unified credit that you're allowed to have that's going up every year. As it is now, we want to die in 2009 or 2010 when it's up to the maximum amount. We hope that estate taxation will go away before then. We don't know. None of us are, unfortunately, none of us are able to see into the future to know what Congress will do with that. But you need to seek estate tax, any kind of tax information from a qualified tax advisor, a tax attorney or CPA who knows what they're doing in this particular area. In 2007, you're allowed to deduct 100% of any value of a gift to a spouse. That's called the marital deduction, and that's where the U.S. citizenship comes into play because that's not available if we have non-citizens. The property has to be bequeathed to a surviving spouse, and it has to be included in the decedent's gross estate. So it has to be listed on the estate tax return. If an estate tax return is filed, it should be listed in the probate inventory if a probate proceeding is underway, and if not, it's not really important unless it's a taxable estate. So you'd have to file a 709, which is an estate tax return, has to be included in that. The gift must not violate a terminable interest rule, which means it has to go to some third person upon the occurrence of an event or some passage of time. There are rules about complex and simple trusts and the manner in which they are taxed. Generally, a credit shelter trust, which we're going to illustrate in just a minute, and a Q-tip trust are both subject to a $5,000 or 5% of the corpus of the trust every year to the surviving spouse during their lifetime, and then the surviving spouse's death goes to the named beneficiaries. A Q-tip qualifies for the marital deduction. If the surviving spouse receives all of the income, it's paid annually and has the exclusive power of appointment over the property, which means they get to decide where it goes among a group of people. And a non-charitable portion of a charitable remainder trust is also qualified for the marital deduction. So if we're planning for a married couple whose estate exceeds the unified credit, say that your estate is over $2 million, we want to maximize the unified credit of each so that we can pass $4 million estate tax-free. So we need to look at the couple together. So if the person who's died owns $4 million and leaves it all to the surviving spouse, then the surviving spouse dies owning that same $4 million. The exemption is only $2 million, so $2 million of it is taxable, which is about $800,000 in estate tax. That can be easily avoided by having the decedent have a will or a trust that provides for a credit shelter trust. We have the maximum amount that can be passed estate tax-free go into the credit shelter trust. The surviving spouse receives the remaining $2 million as marital deduction property. Then at the death of the surviving spouse, we pass $4 million estate tax-free, and we've saved $800,000. $800,000 in taxes versus however much your estate planning attorney is charging you to make this estate plan is not a tough decision for you to make. Okay? You need to look at the balancing act and make sure that you understand exactly what is being done and what you're doing and how you can maximize the amount that you can pass to your heirs. The generation skipping tax I've just put in here for your information. Most people do not do generation skipping unless they have tremendously valuable estates, and I don't want to know any more about tax than I already do. Please consult a qualified tax advisor to tell you about this and whether it's appropriate for you. Elder law issues. And this is the area of law that kind of throws a wrench into things, because most attorneys are good at one particular area of law, and that may be real estate. Maybe be a real estate attorney. They may do, 100 residential closings a month, and they're a good real estate attorney, and they're good at bringing actions in court to resolve title issues to real estate. Or they may be an estate planner, and they may be really good at tax planning and know all of the rules associated with tax planning. But elder law is planning for long-term care and disability, and that's what's important for 80% of the people who own property today, because they are over 70.